Breaking news out of the state of Maryland, believe it or not. We have a partial win, a good win, because Maryland's a terrible state when it comes to the right to keep and bear arms. A partial but significant win in federal district court there in the Kipke versus Westmore case, dealing with quote-unquote sensitive places, which is really just a euphemism for government-mandated gun-free zones. Stay tuned. We're going to break down this opinion when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. For those of you who've already bought the book and have reviewed it, feel free to leave a review on Amazon. It's always helpful to me to see comments. I do read all the reviews on Amazon, so I'd appreciate that. If you've read the book and have the book, take a look at it. Okay, folks, so we have breaking news out of the state of Maryland. As you know, Maryland is generally speaking a terrible gun state, okay? As a result of that, we get a lot of bad gun control laws, despite the low crime rates in places like, well, Prince George's County, for example, and Baltimore. Nevertheless, despite the quote-unquote success of gun control laws in Maryland, the reality is we're lucky to get anything good out of that state when it comes to our Second Amendment rights. And we did actually get some significantly good news today when it comes to the ability to keep and bear arms, specifically your ability to carry guns concealed in public spaces in the state of Maryland. Specifically, a federal district court judge today in a series of cases, including Kipke versus Westmore, out of the District of Maryland, has found that it is unconstitutional under the Second Amendment to ban the carrying of guns within 1,000 feet of a public demonstration, to ban the carrying of guns on locations that sell alcohol for online consumption, and also, and this is very important, that is unconstitutional to ban the carrying of guns on private property without the owner's consent, which is the so-called vampire rule, which is the metaphor that says, as you know, vampires cannot enter a home or a place without being invited in. And the argument is by the anti-gunners, and I'm happy to report has failed in every single court this has been argued. The anti-gunners want to say that you can't bring a gun into any business established, for example, or any private property without first getting the express permission of the owners, which requires, let's say, a gas station on I-91 or I-95 or whatever, to basically post a sign that says guns are allowed. And if that sign is not there, then you can't carry a gun on that unless you know the owner and the owner says you can carry guns, which who knows the owners to any gas station in America? Very few people know those owners when you drive up and down the highways. So anyway, the good news is that law in Maryland was declared unconstitutional. So the good news is, again, 3 wins in this district court. One is you can continue to carry guns in locations selling alcohol for on-site consumption. You can carry guns within 1,000 feet of a public demonstration, assuming you have the proper permits and everything else is lawful. And of course, you know, the ban that says you cannot carry guns on private property without the owner's consent is again found to be unconstitutional. Now, with that said, there was a lot of other spaces where the judge upheld the basically upheld the laws that prevent you from carrying guns in the state of Maryland in public parks, public transit facilities, stadiums, racetracks, amusement parks, casinos, museums, healthcare facilities, school grounds, and government buildings. So all of that has been upheld as constitutional. Now, this opinion, which I'll put a link to down below if I can, is not very good. It's kind of very perfunctory. It relies upon a prior decision he made on a preliminary injunction a while back. So, you know, not a lot of analysis here. It's not going to, you know, set any records for intellectual prowess or anything like that, let's say. Nevertheless, we did get a nice win in Maryland on these 3 issues, and that is a positive because, again, whenever we're in a terrible jurisdiction, well, it's better to win 20% of something because 20% of something is better than 0%, and I'd rather at least win these issues than nothing. Now, I should say what's particularly important about this decision, and this is another nail in the coffin of the so-called vampire rule. See how I'm combining all the metaphors of coffins, nails, and coffins and vampires, you get the point? Or maybe we should just say it's another stake through the heart of the anti-gun vampire rule. The bottom line, this is extremely important because, again, that rule that says you cannot carry guns into a public place without the permission of the owner is very pernicious and dangerous. This is a new idea that came out, I think, by some academics about 4 or 5 years ago in the anti-gun movement, as I recall, and the anti-gun movement latched onto this, thinking this is a great way to basically remove the benefits of the U.S. Supreme Court's decision in Nyserpa versus Bruin by saying, okay, we're going to give you a permit, but you're not going to be able to carry it anywhere because you can't get permission from the thousands of places you frequent because you don't even know the owners of these gas stations or these convenience stores or these supermarkets or these diners or these restaurants and so on and so on. But I'm happy to report that no court has accepted that argument, including this district court in Maryland. And that's why that's very good news, because even if the so-called anti-gun courts refuse to accept that nonsensical vampire rule argument, sometimes referred to as the default rule, meaning you can't carry, is the no fault. The default is no carriage, or the presumption is no carriage, whatever you want to call that rule. The fact is that no court has accepted that is extremely good news for us, because that is a particularly dangerous theory that could be used against us in a big way. So I'm happy to report that yet again that theory has failed, even in the District of Maryland, which again is not a very good gun jurisdiction. So there you have it, folks. Breaking news. A lot more we're going to be covering coming up. Keep in mind that this is the time of year. This is inside baseball information. This is the time of the year where the one-year federal law clerks for federal judges are turning over, meaning the current law clerks are starting to leave to go work usually for law firms. The law clerks that are coming in are now coming in as a consequence. We probably will see a long list of court cases being decided as the old law clerks in the federal courts are in the process of leaving. So they're going to want to try to get their opinions out the door before the new clerks come in so they don't have to get up to speed. So I think in the next couple of weeks, we're going to see a lot of decisions coming out the door over the next few weeks, because the old law clerks are going to be leaving those posts and new law clerks are going to be coming in. By the way, federal law clerk positions are extremely prestigious to get. They're very hard to get. They're really something you do immediately after law school. So you go from a prestigious law school usually to a federal law clerkship for a year. And then after that, you go usually to some prestigious job somewhere making a bunch of money. That's usually the career path when you deal with federal law clerks. That's not necessarily the case with state law clerks. But again, we're talking about this generally speaking. So again, just so you understand some inside baseball, the way that lawyers will talk about these things and how they perceive things, that this is the time that the federal law clerks' one-year positions in these federal courts are swapping over. And again, when the old law clerks are leaving, they try to rush their work product out the door and finish up all the cases they were working on before they move on to their next career position. Okay, so there you have it, folks. Hope you learned a little bit something here about the law and the Second Amendment. Make sure you follow me on X at 4 Boxes Diner. Don't forget to subscribe, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.